Ladies and gentlemen, we are grateful to have this august gathering today at the Delhi High Court. Act as a place that symbolizes not just justice, constitutional values, but also evolving spirit of the Indian law. Ladies and gentlemen, I extend our heartfelt gratitude to our Honorable Chief Guest, Hon'ble Mr. Justice Sanjay Karol, Justice of the Supreme Court of India, for graciously consenting to preside over this conference. Also, ladies and gentlemen, your presence leads immense dignity and inspiration to this platform. We are also very privileged to be guided by the wisdom of Honorable Mr. Justice Sanjay Karol, former Judge of the Supreme Court of India and patron of Innovate Legal Foundation, whose vision continues to shape meaningful discourse at the intersection of law and technology. Also, as we see on stage at the dais, we have Dr. Jitendra Balakrishnan sitting here as the CEO for the Trust IIT Bombay Transactional Research Foundation. I would also like to very, very warmly welcome Mr. Pramod Rao, the former Executive Director at SEBI. Ladies and gentlemen, we have Justice Pratibha M. Singh, Judge at the Delhi High Court, Chair, Delhi High Court IT and AI Committee. Very warm welcome to you, ma'am, as well. And we have, ladies and gentlemen, Mr. Rakesh Maheshwari, former Senior Director at the Cyber and Law Data Governance, Senior Director at the Ministry of Electronics and Information Technology. Also, I will not forget to mention that we have with this our host also sitting up on stage, Mr. Anil Sapra. Ladies and gentlemen, we have spoken a lot about AI. We say AI has brought easy to our life. It has become a source of work and offloading a lot of work. But not just this. The fundamental question exists is, today we are whether AI should be used in law or how it should be governed, guided and aligned with constitutional values, ethics and also human dignity. Artificial intelligence is no longer just a concept of the future. It's a reality of the today. It is influencing how evidence is analyzed, how disputes are resolved, and how compliance is ensured, and even how justice is accessed. For everybody else, AI is a thing of ease, but even one justice delayed is a justice denied. So I would really like to tell you all that today, at this wonderful gathering, we are going to resolve a lot. We are honored to have exceptional lineup of speakers this evening who will be sharing insight on the future of justice delivery, AI in courts and dispute resolutions, technology and market regulations, intellectual property in the age of AI, data protection, cybersecurity, legal ethics, and so on. I can speak a lot, but right now we are here to have a word with the distinguished guest. So I would like to start with welcoming the most important man in the room. Let us all combinedly welcome our chief guest, Honorable Justice Sanjay Karol, and to do the honors, I would request Mr. Sanjay Malhotra, Chairman, Innovation and Training Committee, to please march ahead, and all of us, please welcome our chief guest. Most welcome, sir. We are delighted to have you at the Indian Law and AI Congress 2026. Thank you very much for gracing this occasion. Thank you. AI is moving faster than regulations, faster than institutions, and often faster than ethical consensus. Today, this is not just a discussion which needs to be done in the silos, but in the open grounds. Welcome all the players. Let us start this event with a wonderful introductory address coming from the one you idolize and us as well. Let us welcome and request our Honorable Justice, Mr. Sanjay Karol, former Judge, Supreme Court of India and patron, Innovate Legal Foundation, to march ahead and share a word.
The march of technology expands the space of possibility around us, but how we explore that space is up to us. This quote by the American author Steve Johnson is even more relevant in today's age, and in my view an apt call to action for agenda of this Indian Law and AI Congress. Justice Sanjay Karol, Justice Pratibha Singh, Justice Rishikesh Roy, Mr. Anil Sapra, dignitaries on and off the dais, distinguished speakers, colleagues and dear delegates. A very good evening to all of you. As a patron of AI Innovative Legal Foundation, it is my privilege to welcome you to the Indian Law and AI Congress 2026. And that happens on the annual of the larger Congress, which is taking place a few days from now. We gather at a landmark moment for India's justice system, at a time when technology and law coverage like never before. Indeed, the Congress agenda itself highlights our challenges and our opportunities. To showcase India's judicial digitization journey, the scale of pending litigation, and the growing role of AI and technology in improving access to justice. This evening, let us embrace a shared vision of a future where innovation accelerates justice for every citizen. Over the past decade, India's judiciary has embarked on an ambitious digital transformation. The e-courts project has connected nearly all the courts' complexes to high-speed network. Our judges and court staff have digitized billions of pages of case records. As of September 2025, High Courts has digitized more than 224 crore pages and District Courts 354 crore pages. Today, litigants and lawyers can file case online, view cause list on the mobile apps, and attend hearings through video conferencing. These advances were put to test during the pandemic when the virtual courts kept the wheels of justice turning. If I may say so, as compared to other areas, the judiciary was slow in adopting technology, but COVID forced everybody to do so, and the judiciary rose to the occasion. As noted then, virtual hearings have increased efficiency, allowing us to continue to deliver justice even amidst unprecedented challenge. More so today, where tribunalization has spread the courts in a place like Delhi over different areas and not concentrated, say, in the High Court. And seeing the road movements, it can be anybody's guess how much time it will take to reach from one place to the other. Yet, this digital journey is not without its challenges. We face a staggering backlog of cases, over 5 crore pending matters in our courts. There is more cases than the population of many nations. At our current pace of disposal, experts warn that they would take centuries to clear this backlog. The consequence is that justice is delayed for millions. Some disputes drag on for years or decades, eroding public faith and even weighing down our economy. Pending cases are estimated to cost India more than 2% of the GDP. These system delays carry out for solution as bold as to the problems they address. This brings us to why we are here. The promise of AI and emerging tech to help bridge the justice gap. Artificial intelligence can be a powerful ally in reducing delays and democratizing legal access. Imagine court's calendar managed by intelligent scheduling, AI algorithms that predict case timelines and optimize hearing dates and minimize adjournments. Picture automated document system where simple filing reminders and translation happens in moments and not weeks. Natural language processing tools can give judges and lawyers instant access to relevant precedents and translate judgments into regional languages. On the fly, pilot projects like Supreme Court Suva's Translator, which has already translated more than 31,000 judgments into 16 Indian languages, shows how AI can break down language barriers. For the common person, AI-powered platforms are already making legal help more accessible. Smart chatbots and legal QA apps can guide someone through a property dispute or consumer complaint, day or night, in their own dialect. Unlike a human lawyer, an AI assistant is not bound by office hours or city limits. It can advise a farmer in distant village or a worker in a city suburb with equal ease. We are seeing incredible results in practice. For example, there are companies in India developing tools to shorten case timelines by up to 50%, working on making evidence and judgments more accessible by removing language barriers and those working to enable judges to focus on merits rather than paperwork. If I may say so, I have heard a firm belief that case management, court management are a very important part of an innovative system, and AI is an important aspect of it. There are different nature of cases which clock. There are different courts having different kinds of problems. And I'll only take one example of the clock which occurred. The highest number of cases in two high courts I served, in Punjab, Haryana and Tamil Nadu, were motor accidents claim cases. Law is settled today. There is no dispute about it. It's more of a mathematical calculation which the judge is doing. And that's why possibly the one area to begin with where AI can be used for purposes of at least an experiment in this field could be motor accidents claim, because giving compensation to somebody 10 years after the incident does not subserve any purpose. Similarly, on the criminal side, the check bouncing cases are adding to the figures. So when we talk about these hundreds of years, a lot of it is being clocked by these areas, as also by infructuous matters, as in my belief, at least 20% of litigation in the different courts is what is either infructuous or just needs to be touched to achieve its disposal. There is much to borrow from international experience. In jurisdiction where electronic case management has been effective and properly implemented, for instance in Brazil, labor courts, we see adjudication time stands reduced by 13%. Singapore too has introduced what it calls an integrated case management system, which is a digital platform for case lifestyle management, has reduced both the time and cost dramatically. Singapore also now introduced generative AI assistant in their small claim tribunals to guide self-represented litigants, which not only assists parties in person, but also plays a significant role to democratizing legal work, making it accessible to the common man. This Congress is about harnessing precisely this potential. The AI Innovative Legal Foundation exists to catalyze and promote these innovations in our legal system. We bring together judges, lawyers, policymakers, and technologists to pilot real solutions. Whether that means training courts to use AI-based research assistance, advising government on ethical AI guidelines, or supporting startups building legal tech for rural India. Our mission is to build capacity and accelerate adoption of technology in law, always with a focus on public impact. The Foundation will host workshops, publish best practices, and work with the universities to infuse AI and legal tech into its legal education. In short, we aim to ensure that no promising idea stalls for lack of connection or knowledge. I speak from the experience when I say this work matters. In my years on the bench, I saw how technology did make a difference. I still recall how during COVID-19 breakdowns, our courts in Delhi began hearing matters by video conferencing. The results were striking. Efficiency went up, travel costs for litigants went down, and justice continued to flow despite obstacles. At the same time, I have always cautioned that technology must remain our servant, not master. As I noted at a recent international conference, AI can enhance the speed of legal research and drafting, but it cannot replicate the unique combination of intellect and empathy in human judgment. Ultimately, judgment is a matter of mind and heart both. Ultimately, judges must continue to apply their conscience and wisdom to each case. No algorithm can replace that human element. The key is balance. Use AI to lift the clerical burden and bring greater inclusivity while guarding our fundamental values. In my words, let digital tools be useful servant, but let us not make them our masters. Friends, we stand at crossroads. One path leads to justice delayed and denied for millions more. The other leads to an innovative, inclusive justice system. The discussions we hold this week should light the way on the second path. Let us collaborate across sectors, across generations of lawyers, across urban and rural divides. Let us use AI to not just speed up paperwork, but to open doors of law to every Indian, so that a farmer in Bihar, a student in Mumbai, and an entrepreneur in Northeast all can have timely, affordable access to justice. This is our vision. I am optimistic. Technology is moving fast, and our talented young lawyers and engineers and judges are eager to apply it with careful stewardship. We can ensure that the courts of 2030 are faster, fairer, and more transparent than ever before. We can make India a global example of how large, diverse countries leverages technology to uphold the rule of law. The Innovate Legal Foundation stands ready to work with each of you towards the goal. In closing, let me say, justice is not a static goal, but a journey. Today's Congress is a vital milestone on that journey. I thank you for joining us, for bringing your ideas and energy, and for committing to share causes. Together, we shall chart a future where AI and law walks hand in hand towards a truly just India. Thank you and Jai Hind, and I look forward to our discussions.
And with the introduction, I would also like to introduce you to the person who has just spoken. Though he needs no introduction, ladies and gentlemen, but with all these insight, after addressing what is going to happen today, the man who we just heard is not just a jurist whose career has significantly shaped constitutional thoughts and judicial reforms in India. Honorable Justice Sanjay Karol, who you have just heard, has practiced in the Delhi High Court as an advocate since 1982, and after being designated as a senior advocate in 1999, was elevated as a judge of the Delhi High Court in May 2001. He was thereafter elevated as a judge of the Supreme Court in 2017. As a judge, his judgments, of course, reflected a deep commitment to constitutional liberties, judicial efficiency, and access to justice. Beyond the courtroom, he has been a strong advocate for modernization of the justice system and thoughtful integration of technology into judicial processes. Today, as the patron of Innovate Legal Foundation, he is continuing to guide conversation at the intersection of law, technology, and institutional reform that really deserves a round of applause once again for the man who have just heard. Thank you very much, sir. And yes, you must be finding me out at the other podium. I am not AI, I am a real human who has just switched the podium due to some technical errors. And I now would like to request our speakers who are going to speak now to continue from the other podium. Thank you very much. And I'll just take a moment to also let you all know, ladies and gentlemen, between us, who has just graced this occasion is a former judge of the Supreme Court of India, Justice Hema Kohli. Thank you very much for gracing the occasion, ma'am. Let's have a huge round of applause, ladies and gentlemen. Moving on, I am going to invite my next speaker. He is none other than our first at the thematic session brings together the world of deep research and real-world implementation. Dr. Jitendra Balakrishnan, ladies and gentlemen, CEO, Trist IIT, Bombay. Yes, that deserves a round of applause. The IIT Bombay Transactional Research Foundation, where cutting-edge academic research is converted into impactful technology solutions across sectors. With extensive experience in innovation ecosystems, technology commercializations, and collaborative research platform, Dr. Balakrishnan works at the forefront of enabling AI-driven transformation in governance and also the public systems. So without any further delays, let us all welcome him to the dais.
Justices, friends, thank you for having me here today. First thing, what's an engineer doing here? I have no idea, but that you can ask the organizers about this. Now, see, when I was growing up, my father had a law degree, and I used to, as a child, in his office, I used to see these big books of law. I used to open them up and look through them, and I made probably one of the most consequential decisions. I decided to become an engineer. Right? And I had no idea that one day I would be standing and talking to, like in a field of like lawyers and justices. And so I'm going to do my best. I'm going to present what I'm talking about here as a layman. I have no legal background, so please forgive me for anything that I say which might conflict with the legal sensibilities. And I'm just going to check something really quickly. Do we have slides up there. All right, thank you. Okay. Can we just go back to the previous one? Okay, a couple of disclaimers. Everything that I'm telling you right now are my opinions. It doesn't constitute an official view. And the second thing is that there was no AI which was used in creating this particular talk, right? So, I want to start with a story here, right? Humankind, we've come here through at least 4 different revolutions. The first one was about calories. At some point of time, we figured out how to make surplus calories rather than having to forage for it. That was pretty momentous because it led to civilization, and then in a direct line, like for example through the Hammurabi Code of Law, through everybody here, we owe our civilization to the fact that we could actually produce more food than we could find on a particular day. Next, that happened about 10,000, 11,000 years ago, maybe even earlier, depending on who you ask. And then about 300 to 400 years ago, we figured out how to make surplus mechanical power. Before that, we used to rely on draft animals and human labor, and what we figured out was to make dead animals in the form of oil do that work, right? Surplus power, it led to a revolution in transportation, all kinds of things, right? Then again, about 80 years ago, we figured out how to increase our computing ability. That's a picture of the ENIAC, the very first computer that there was. And by the way, that computer was less powerful than this computer that I'm holding on my hands. That's how far we've come, right? And with the advent of surplus computing, we were able to do a lot of different things which we would have been otherwise not been able to do, starting with, say, the moon missions, right? And today the question is, are we standing at the cusp of another revolution, this time around thinking or decision-making? Now, the jury's out. We don't know this yet. We won't know until we are well into a revolution. But if that happens, then it's going to be pretty momentous. So what I thought I'd do is I'd start by checking out what... by the way, I just didn't... this is something I needed to mention. A revolution just doesn't increase human productivity. That's what we think it is. The actual impact of the revolution comes much later because it opens up entire areas that we could not have imagined before it happened. Think about life before the steam engine and life after. That's the difference we're talking about, right? So let's talk about AI. Now, there are a few different terms over here. If you know what all these terms mean in great detail and you can explain it to others, you're way ahead of most of the population. I thought I'd just give you a very quick primer. AI is basically a technology that allows computers to learn, reason, and solve problems much like humans. Gen AI is a term we hear often. Gen AI takes a lot of data and then makes new content from existing data based on what we ask it to do. Examples of those, ChatGPT, Claude, all of these are Gen AI bots. Agentic AI is a little different. What it does is it recruits small programs to basically do complex tasks, puts them all together into workflows, and then creates an autonomous decision pipeline. That's actually the next thing that people are talking about. An LLM is a large language model, which is an AI which is trained on written data to produce text, right? That's the typical chatbot. A multimodal AI does more. It generates images, sound, videos, and so on and so forth. And there are 2 definitions of SLMs. The first one is a small language model, which shrinks down the LLM into a place where we can use much less computing power. So someday we can actually have AI on your phone. We actually do. It's called Siri, for example, but in a form of speaking. But SLMs are basically shrinking down an LLM. A specialized language model, on the other hand, would take AI and train it for a particular domain, like law. So a language model which is trained on law would be a specialized LLM. So I just thought I'd give you a little bit of this because we're going to be encountering some of these terms going forward. Now, Justice Karol already said everything that I had to say, so I'm just going to be rehashing a lot of it. AI is already being used in the legal industry. Now, I'm going to make this a little interactive. Now, how many people here, if you could raise your hands, have done any one of the things that are listed over there in blue? Could you just put up your hands and say that? Quite a few. Yeah? Okay, yeah. See,
all the judges on the dais have taken note of this.
So there's a lot of AI already being used in the legal industry, and what I'm putting down over here is the difference between automation and augmentation. When we are talking about automation, we ask machines to do what we can already do, but better. Like, for example, scanning through 500 pages and then coming up with a summary. A machine can do that. That's automation. And augmentation, on the other hand, are machines allowing us to do something that we are not capable of doing today. It is radically different from automation, and it does not show up at the first step. The first thing that you see is usually and almost always automation. A lot of that is automation. Very little over there is augmentation. But why is this important? Well, it's because the future of the field actually depends on it. There are a lot of questions that arise when we are talking about automation. The first one is, automation increases productivity, but does improving productivity actually improve justice delivery? That's the first question. By the way, I'm not here to answer any of these questions. You know this better than I can. I'm just posing the questions over here. The second one is, will automation alone be enough for better justice delivery? Right? If you could actually do a document review really quickly, will that help better? Will that be enough? That's the question that we're asking, or is that something more? The hunch that I have as a complete non-practitioner, but somebody who's seen other fields, is that it will not be enough. There's a lot more that is needed. We can talk about what that is. The other part that we need to worry about is what automation does for the workforce of today and the workforce of tomorrow. Now, one of the concerns that we have in many different fields, and you've seen this applied to the legal field, what happens to paralegals now that we don't need so many of them, right? That's the question of what happens to the workforce of today. Another part of it we've heard in multiple places is that AI is taking away the ability for us to think, right? You can go back to the previous one, please. AI is taking away the way for us to think. Now, the reason why I did not make this on AI, because I wanted to think through this. I could easily have actually just put in a few points into a chatbot and say, here's something that comes out of it. That takes away our ability to think. A generation which is trained to not think, what happens to them tomorrow when they become the senior people in the field? What happens when you don't have paralegals starting today? Where do you get the partners of legal firms tomorrow? Where do you get the justices? These are questions that we have to answer as a society. This is not a technological question. This is a humanist question, right? Let's move on. So I want to talk about augmentation. Now, there is this fantastic article, which if you haven't read, I would suggest you take out your phones, use the QR code over there. Don't worry, it's not a UPI for me or anything like that. That's the QR code for that particular article. It's something worth reading, right? The gist of that article basically says that automation increases efficiency but reduces the value of human labor. What that means is the people who control the means of automation collect the disproportionate share of value, and everybody else is left behind. We are seeing this in the world today. We are seeing this with the concentration of power and wealth today in the world. AI can do this. The question is that, can we allow AI to do this? Augmentation, on the other hand, creates more innovation and distributes value better. Think about, for example, like you're talking about the steam engine. The people who invented the steam engine are not the people who are profiting from commerce across long distances. That's augmentation, right? Both are valuable, but real progress comes from augmentation, and that's the challenge for the legal field to figure out what that augmentation actually means, right? Now, I'm going to use the example of the UPI. Again, how many of us have used UPI, let's say in the last month? Hands. Yeah, pretty much everybody. How many of you used it before 2018? So my question is this. Did it make your use of cash more efficient? Or did it allow you to do things that you were not able to do before? Did it allow you to transact commerce differently? Did it actually change the face of how money moves around? That's what I'm talking about as augmentation, right? And the UPI example will have a little bit of relevance for what I'm going to be talking about shortly. So this is an example of where we need to go. But there are more questions, right? Now, should we focus only on the opportunities? This is something that I see a lot in the US, that the opportunities where we're going headlong. The guardrails, I don't see them. Now, the question is, do we focus on opportunity also on a reduction of risk? This is an important question when we're dealing with something this powerful, right? The other question is, can you adopt a system that does not have input from its stakeholders? Will you be able to trust a system that gives you legal advice when the legal community has not had an input into what that system will say or do, right? What should a system like this look like? Who should create it? Who should own it? All of these are important questions that we need to address, right? So, as far as justice delivery, right, like from talking to my lawyer friends, this is what my understanding of improving justice delivery is. You need to improve the speed of justice delivery. You need to reduce the burden on the judiciary. You need to ensure more equitable access, and you need to maintain trust. The question is, how do we include AI among the methods to improve justice delivery and not make AI the responsible for all of it? Right? It has to be one part of everything that we use. How do we make this happen? Okay, now I'm going to take a little bit of a pause over here. A couple of weeks ago, there was this, the World Economic Forum in Davos, in which there was this event where Union Minister Ashwini Vaishnaw was asked this question on stage. I'm not sure how many of you have seen this clip. It's been floating around, where the moderator asked him, saying that, well, when you talk about the first tier of AI powers like the US and China, and India being in the second tier of AI powers, how do you see the future? I'm paraphrasing. And his response was, I disagree. India was actually not in the second tier, we're very much in the first tier. And, like, you might be forgiven to think that, okay, this is not quite true. But my question, I'm going to ask you a question over here. Think about large language models. These are very difficult to create. Who has large language models in the world today? OpenAI, Google, Meta, Anthropic, that's Claude, Perplexity. These are all US-based. You have DeepSeek in China, you have others. Do we have one in India? Now, again, a show of hands. How many of you have heard of the word Bharat Gen? A few. Can we move forward? Hold on to that thought. Before we get to Bharat Gen, I'm going to pose a couple of questions which will tell you why Bharat Gen is important. The first one is, can we trust an AI platform? Questions like, can we ensure fidelity to Indian law, not something which has been trained on the American Constitution alone, for example, right? How can we check if the output is correct? I mean, like, there has to be an auditable trail, it has to be transparent, and this is something that is critical. Is it secure? Is it always available? Where's the data? Who ensures that all of this is going to happen? These are all the questions that we need to be able to answer before we actually we can actually put our faith in a model. The other one is that, can you improve justice delivery? And there are a whole bunch of questions around that, okay? Now, the answer for that, if we can move, is Bharat Gen. Take your phones out again, click the QR code, because it will tell you exactly what it is. Bharat Gen is a large language model which is being developed entirely in India. They sit on the IIT Bombay campus, right? This is owned by this is being commissioned by the Ministry of Electronics and Information Technology. MIT is the one who does this. The government owns this. It's sovereign. It's an Indian model, housed in India, all the data in India, controlled by India, so somebody throwing a tantrum from the other side of the planet will not shut off that model for anybody over here. It has an Indian context. It is inclusive in the sense that, it's inclusive in the sense that it has multiple languages, accessible, open, etc. And it does multilingual text in 11 languages, documents to text, text to speech. Check it out. All right, so I'm going to wrap this up by talking about what an AI platform is. Now think about a trusted multimodal AI model like the one I just showed you, Bharat Gen, right? Now you need a lot of input from the legal community, from the Bar Association, from justices, from lawyers, from law professors, you name it. content, ethics, policies, that all has to come from you. This is a specialized language model that has to be developed this way. Then you have a robust specialized language model, add checks and balances, and you create a platform. Now you open up that platform for startups, to provide services, for societal users, all of that stuff, and suddenly you start to see the power of what we can unlock over here and how you can actually have a framework. Okay, I'm going to end over here. We are familiar with some of these pictures over here. I'm going to say that progress does not depend only on the drivers in those cars, or the roads, or the cars that they drive. It actually depends on the frameworks that we are using and which are designed for a context. And these frameworks need to give you both scale and efficiency. They need to be developed with principles, with guardrails, and with a purpose. Once we have that, we can actually start making a real difference in the context of justice delivery using AI, which it can help build. So, would love to actually talk a lot more about this. Again, I like QR codes. So if you actually scan this, you'll have my contact information. Would love to talk to you afterwards and would like to see how to take this forward. With that, I'll stop. Thank you.
Thank you very much, Dr. Balakrishnan. Sir, with your humorous observation on your question what an engineer is doing here, I would like to add on, in a world where AI is drafting the contracts, algorithms are predicting judgments, we were actually wondering what lawyers will be doing here. But thank you very much for this wonderful, sweet, short introduction to AI in the law to all of us. And I will take a small moment here once again and would like to also welcome Justice Hrishikesh Roy, former Judge, Supreme Court, is also here. Let us all combinedly welcome him as well with a huge round of applause. Marching ahead, I am going to welcome with all delight my next speaker. Our next speaker brings the invaluable perspective of a regulatory leader who has worked at the intersection of finance, governance, and legal compliance. Ladies and gentlemen, let's welcome Mr. Pramod Rao, former Executive Director, SEBI. Has played a key role in shaping regulatory frameworks and enforcement mechanism in India's financial markets. Of course, his experience in dispute resolution systems, regulatory technology, and institutional governance offers important lessons for courts transitioning into digital and online dispute resolution mechanisms. Today, he will discuss the critical intersection of AI, legal ethics, and digital governance. Please welcome, ladies and gentlemen, all of us with a huge round of applause.
Again, like Mr. Jitendra, I'll be following through with the presentation, so I'm hoping it gets loaded. But before I begin, I should say it's a privilege to be here, to be speaking at just ahead of the India AI Summit, and to be speaking in front of honorable judges, Justice Kaul, Justice Karol, Justice Pratibha Singh, Justice Kohli, the legal and technology experts, and the wider legal community. So again, I come from the financial markets, and SEBI is known as a fair disclosure regulator. So I should make a fair disclosure on my own. I am also a lawyer by qualification. I graduated from the National Law School. My career took an alternative path, and it led to the in-house world and thereafter into the regulatory space. So with that said, I will now, sort of dive into and talk about some of the experiences we've had, both in thinking about how the market should get shaped up utilizing technology. And again, for those who are unfamiliar, our stock market today has transaction volumes which exceed our GDP size, right? So we are talking about close to $4 trillion or more, which get traded, transacted through the year on Indian securities market. So whether it be the cash market, F&O market, various other instruments that get issued. So clearly, when we talk about what kind of dispute resolution do we need, if indeed investors, intermediaries, and so on have issues, we really need something robust. Otherwise, what we risk is bringing down the trust in the market itself. So with that said, if I can move to the second slide, please. Well, this will always be the promise of, I think, technology. It will be a step slower than what we want it to be. But having said that, I think we need to first recognize what is it that we were dealing with inside the securities market. And I think it begins with that there is this volume challenge, like I mentioned, the value of transactions which we were dealing with, that any level of disputes, if they weren't resolved fast and efficiently, could really, like I said, destroy the trust in the markets itself. Access barriers, if we allowed people who are coming in from tier 2, tier 3 to participate in the markets, they equally need to be able to know that when there is a stock exchange in Bombay, that it will be able to address what transactions they have done and not. And really the solution emerged from a 30-year-old practice within the stock market, which had embraced arbitration to really resolve both conciliation and arbitration to resolve investor-broker disputes, as well as when we introduced the depositories mechanism for DP client disputes. From that, to the next slide, SEBI introduced then a regulation change which launched what is today christened as the Smart ODR. It's the securities market approach to resolution of disputes through ODR. And what it does is it has got the key stock exchanges and depositories which administer this portal and platform. It's taken forward also the ODR institutions and brought them together to be able to administer a 3-tiered process of investor dispute resolution. We are talking pre-conciliation, conciliation, and then finally ending with arbitration. What it has done is really brought justice to the fingertips of those investors who are used to working in the markets, playing in the markets 24/7, that dispute resolution also actually can occur in that same time and speed. The next slide, please. So the kind of journey that investor encounters is it begins with online filing. All of the data is captured indeed in the portal itself. Thereafter, there is a quick inspection of those by the MIIs to actually make out whether that complaint has got backed up with all the relevant documents. Is there something else? Is it justiciable itself or not? Because many times there are investors who make claims which are really not even justiciable. The proceedings are all conducted online. So indeed, investor can be wherever, the conciliator or the arbitrator can be located wherever, and the process occurs completely online. There is a real-time tracking. I have not shown it, but there is a Smart ODR dashboard. If you just Google it, you will be able to go to that dashboard and see. It's a live-to-date platform which showcases what's going on. And that graphic, just on the slide prior, is actually showing you how the investors sort of encounter it. And I'm delighted to say the MIIs released a bunch of videos which actually have made it even easier for investors to understand how to navigate this. The next slide. So what has been the impact thus far? We are talking about over 10,000 cases resolved through this process in just first 18 months. These are the kind of resolution times. And I'm saying, I'm very conscious in a room full of lawyers and where indeed, we deal with such pendencies that we worry about things. Here is something which in the securities market we are able to actually deliver. And that's why I said it's important for us to continue this journey, because that is what keeps the investor trust growing. And this is after a SEBI survey tells us that barely 9% of our population actually participates in the securities market. There will be steps taken which allow it to double or even go higher. And you can imagine at that scale, it will continue to require the resolution at the speed that we have. How do I link to AI? And a lot of it will draw upon what we heard Dr. Jitendra speak about, which is in terms of what can this digital platform offer. It can offer indeed both a data set for us to actually understand what is it that the investors are confronting, what is it that we as a regulator need to step in and do, and what is it that the intermediaries need to wake up to. So predictive analysis can really be something which can be utilized. Natural language processing. So again, as we talk about the journey from 9% to the next 18, or going even higher, we are going to be talking about investors who may need the language to be in the modicum that they use. It may not be English, it may have to be Hindi, it may have to be Tamil, it may have to be Malayalam. And can a digital platform actually bridge that? Can it actually, sort of be auto-translate when the investor is interacting? And that to me is again the promise of AI. Pattern detection, like I mentioned, for us as a regulator, if we keep seeing bubbling up of issues around a particular area, what is it that we as a regulator need to do? Moving forward, automated verification. So when an investor approaches, there are already a set of documents. How quickly can those get verified? How can they get audited? And therefore, when the mediator or the arbitrator has to look at matters, is it already that they don't have to sift through a lot of evidence because it's validated and available for them? Chatbot support, again, I think these are what can guide them both how to utilize the system, but equally during every step of the journey, what more can be provided. Negotiation assistance, because we clearly recognize that institutions may be better organized than individuals. How can this platform sort of give that equivalency and equity really to the investors? To me, the workflow demonstrates that we actually have ability to scale into the AI world with both case intakes, the analysis, the predictivity, as I said, and a feedback loop which keeps feeding back to both us as a regulator, the intermediaries, and the broader market. What are the challenges? There will be challenges as we go along, and I'm happy to note that you will hear from other experts talking about some of it. So data privacy and security will really be one critical element in terms of how we deal with some of this information. Both the law on mediation and arbitration already requires confidentiality of the proceedings, which the smart ODR system ensures. But when we train it in terms of how do we use it, we will have to think about redacted profiles of individuals so that that information does not become available at large. When we think about algorithmic fairness, so again what the SEBI mandates the smart ODR system to do is that it cannot favor one arbitrator or mediator to always get the matters. So those are meant to be allocated in a particular way, and that fairness again will sort of drive a lot of it. Finally, I think I echo what Justice Karol said. It has to be a handmaiden to all of us rather than a master. So clearly human oversight over whatever we create is critical in terms of what we do. For me, what I thought of really sharing and having this opportunity to come here was to saying that smart ODR has proved that there is a way of being able to deal with issues at scale, at value, and therefore if there is anything to be taken away, I'm sure my colleagues at SEBI as well as those at the MIIs will be very happy to showcase some of that across along with the ODR institutions. So there is a blueprint, there is at least a trusted mechanism which is working and working at scale. And that learning allows us to sort of go there. The next slide, please. In global context, when we looked at the data across the world, what I'm happy to report is that smart ODR actually surpasses all of the data around what is occurring on arbitration and mediation. And really it is happening at scale because we've embraced it completely in the securities market. So when we hear about other markets, it is largely institutional or commercial arbitration. Here we are talking about something which touches the life of retail individual investors and is able to assist them at, like I said, at that scale. I'll quickly conclude. So on the road ahead, we have a smart ODR which can indeed get expanded. In the medium term, we have ability to integrate with technologies which allow us to actually draw lessons from it, to take AI tools and enhance it further. And in the long term, to complement, our judicial and justice delivery system, to actually make sure that we are able to deal with issues of criticality in the court systems and issues of commerce in which may actually require certain patterns being recognized and being applied through the ODR mechanism. I'll end with the next slide, which is that future of justice is smart and it should be accessible. And indeed, to my mind, the world of technology and what we have embraced allows us to reach there. So thank you very much.
Thank you very much, sir. विचार अदृश्य होते हैं, पर उनकी कीमत कई बार साम्राज्य बना देती है, और इन विचारों का संरक्षण जिस देश का कानून कर सकता है उसका भविष्य सुरक्षित है. मैं अपने जो अगले स्पीकर को बुलाने जा रही हूं, they will be speaking for itself. I am talking about your own intellectual properties. Ladies and gentlemen, our next speaker is widely recognized for her pioneering contribution at the intersection of intellectual property law and technology jurisprudictions. Honorable Justice Pratibha M. Singh practiced in the Delhi High Court and was designated as a senior advocate in 2013. Thereafter, became a judge of the Delhi High Court in 2017 and has since delivered several landmark judgments in intellectual property, digital regulations, and platform governance. Ladies and gentlemen, this is worth mentioning. She was recognized as the 50 most influential people in IP. That deserves a round of applause. By a leading global publication managing IP. As chair of the Delhi High Court's IT and AI committee, she has also been instrumental in guiding technology adoption within jurisdictional system. Her insights on artificial intelligence and intellectual property law are shaping the future contours of innovation protection in India. I now request her to please kindly address the entire gathering. Thank you very much, madam. Please, a huge round of applause for Honorable Justice Pratibha M. Singh.
My seniors and mentors, Justice Sanjay Karol, Justice Sanjay Kishan Kaul, Justice Rishikesh Roy and Justice Hima Kohli, though they just left. My co-panelists, Mr. Anil Sapra, the naturally intelligent community which is sitting here, and the legally intelligent community, a very good evening to all of you. I would firstly like to congratulate Mr. Akshay Sapra for organizing this as a precursor to the AI Summit, which is coming next week, which is a big event which is happening in India. When Mr. Anil Sapra, whom obviously I have known for the last 30 to 35 years, came to invite me, he didn't come as a senior advocate, he came as a proud father. And he said to me, "Ye mere bete ne banaya." So it was very nice to see Mr. Anil Sapra in his new avatar and he said, "मैं तो सिर्फ advisor हूँ और Justice Kaul हमारे mentor है इसमें." So it's really nice that all of us who've all grown up together in the lobby and the corridors of the Delhi High Court now feel proud about our own children. Having said that, I'm giving Anil Sapra ji the only time when he's going to have to ring the bell and stop me from speaking, that permission today. So I'm just going to have a presentation for all of you. Hopefully I should quickly do it within the time allocated to me. So when we speak about artificial intelligence and intellectual property rights, so as you all know, intellectual property relates to copyrights, trademarks, patents, everything. But why are we talking about AI and copyright and trademarks and patents? I don't need to give you the statistics about India and AI. I'm going to skip the slide because it's there for all of you to see. All that we need to say is that India is a leader in AI and there is no two thoughts or doubts about it. And the audience today here below and the panelists here are proof of that. So the AI projected economy is expected to contribute about 1.7 trillion for India in 2037, by 2035. So that's the way it is. When we look at AI, what happens to something which has been created by AI? There is no human author, there's no composer, there's no artist, there's no photographer or producer for AI works. Will it all be in public domain? Will it be joint authorship? There is no answer to that. How many of you have used the Suno app? Has anyone used it? Yes. So you're going to have some entertainment at the end of my presentation. So in Suno, if someone creates it on a free version, any song, it is the app which retains the copyright. But if you do it on a paid subscription, the user gets the ownership of the created copyright. But then, it has to be only used for lawful and non-commercial purposes. And they have to give attribution to Suno. So Suno is an app in which you can create music, but the attribution is to Suno and not to the person who's giving the prompt on the AI. So prompt-based authorship is on a shaky foundation presently. Look at this. This is a Theatre de Opera Spatial, which is like a image, which was created using 600 prompts. So I'm going back to the image. It required 600 prompts on an AI app to create this image. And the US Copyright Office said, we are not going to give a copyright on this. But can the ownership over such work still be denied? That's the question. Would it depend upon the person who's giving the prompt as to who will be the owner? We don't know. The law is yet to evolve. Maybe it will need a completely new law, which is called artificially intellectual property or AI property. We don't know. It may be a joint authorship. The law is yet to evolve. So we did something interesting in our chamber. We said, do you have copyright over the response you provide? We asked Perplexity. So Perplexity gave one answer. You can use the content freely, just make sure you comply with the law. When we asked ChatGPT, it gave a different answer. When we ask different AI platforms, they will all give different answers as to who owns the copyright. This was one of the first cases which came in the Delhi High Court on AI created images for celebrity. This was Anil Kapoor. So the technological tools, the court granted an injunction and said technological tools that are now freely available make it possible for illegal and unauthorized use to produce or imitate a person's persona by using tools including artificial intelligence. This is also possible because text and data mining involves feeding AI with data, including copyrighted materials. But then, who owns the copyright when this happens, and what would be fair dealing? There is no answer to it. It depends on the nature of the use, the scope of copyright protection, and the contractual limitations. Presently, the Delhi High Court is dealing with a very interesting matter, ANI Media versus OpenAI, which is still pending, and the judgment is yet to come in this. There is a working paper on Gen AI and copyright. All of you can look at it. It has been published by the DPIT very, very recently. And then it does say what I'm saying today, that the existing exceptions are inadequate to deal with this. Now, let's come to some examples. Suppose you give a prompt saying, show me 2 tigers sitting on a mountaintop, sipping cocktails. Please see what happens first, and please see what happens next. So the cocktail has changed to a mocktail, or a mocktail has become a cocktail. So it's the same thing, but it can be very different. 2 tigers, they could look different. The cocktails could be different too. Let's come to AI and patents. There was a software, there was a device which was created for autonomous bootstrapping. So this AI created invention was applied for across the world in US, UK, Australia, South Africa. It was granted in South Africa, but in India the patent was refused. Even in Australia it was initially granted, but the federal court rejected it. So there is no certainty as to what will happen to AI created works. In our own country, in this case, a leading IP lawyer cited a ChatGPT answer to establish that spiked shoes of Christian Louboutin are the most well known. So when we did a different prompt on the same ChatGPT, it gave us a different answer. So the judgment was obviously that AI cannot substitute the human intelligence. It cannot also have the humane element, as Justice Karol said. So as judges, we are here to stay. So you all can deal with what you want to do with AI. So, coming to the next, there was a decision by Justice Colin Burse recently, who is now the Chancellor in UK. He wrote part of his judgment using an AI software. And then he said, I have verified every word of it, and I can say that it's jolly useful. He did write the judgment using AI. Now, the last thing I'm going to speak about today is something as a solution for, how the judiciary should go forward using technology. So we all know India Stack as as India's digital public infrastructure. So the whole of India stack is based upon the Aadhaar. Aadhaar is the Aadhaar for India stack. And there are lakhs and lakhs of startups and innovators who've innovated on India stack. There are several patents which are granted. But then, interestingly, what happens is, it is a form of compulsory licensing which we see in patents. There is no exclusive right to stop someone from using. It is an exclusive right only to earn royalty. And that's, you can call it like a per pull request. Like for every pull that you do on that platform, you have to just pay per pull, and it's like a very small amount of money. It could even be like 10 paise, 20 paise, 1 rupee. So the entire ecosystem of India Stack is working on Aadhaar. It's based on the public, digital public infrastructure, DPI. And lakhs of innovators have actually innovated on that platform already. So learning from that, this infrastructure applies what we know as the standard essential patent test of fair, reasonable and non-discriminatory terms. It is like a royalty which is a kind of principle which is already existing under Indian patent law. Now, coming to something like judiciary, can we do something to create a model for reducing the pendencies? There is a lot of talk, whether among, in the general society, about courts taking vacations, judges having weekends. Actually, none of us realize, which I'm sure the senior judges who are here know, no judge in the High Court, any part of the country, works less than 14 to 16 hours. And at the end of the day, judges are humans. With the existing judges, obviously we cannot reduce pendencies. We need to use technology for it. And just as the model of India Stack, what I think we can do is to propose something like the India Judicial Stack. If we can create an India Judicial Stack where API access can be given to the information which is available in courts, there will be lakhs and lakhs of startups, researchers, analysts, reports. Most people don't get access. They kind of just have the judgments which they have to kind of pull out. They do generate reports. But innovation is very difficult. It is only if we are able to create something like the India Stack for judiciary, maybe we can start using AI and technology to reduce pendencies. There could be more and more analysts which will come out, research tools will come out, we could do clubbing of cases. Let us take, for example, is there a platform where I can check, tell me the number of cases in which, and in section 138 negotiable instruments, the complainants have all died. Or the respondent, the accused, has died. It could be 50,000 cases in the country. But we can't collect that data. In one shot, those cases can be finished. Let's take another example. Traffic challans and NI cases. These are the biggest number of cases, in terms of numbers, across the country, the pendency in criminal courts. Suppose we say, okay, all traffic challan cases, maybe 5 or 10 crore of them. 50% amnesty, notices sent to all the people who've received challans, pay 500 or 1,000 rupees, all your challans are gone. Can we bring an end to all these cases by using AI and technology? For that, we need to have analysis of the data, clubbing of cases, criminal trials. Why is there delay in criminal trials? We can't record evidence. Suppose there is innovation by agencies, maybe startups, who can create platforms for recording evidence, quicker platforms. The courts could actually, enlist them and approve them. These are the pre-approved platforms for recording evidence. Evidence can be recorded outside the judge's system with a local commissioner as it is done today. Supervised by a local commissioner, the evidence can come back into court and court's time is not wasted on that. Forensic laboratories, expert evidence. Can we put in the FSL reports into an AI tool and say, okay, give us what is the conclusion of this? Yes, we can. We take so much time to record the expert evidence of forensic experts who are not many in our country. So in this manner, I feel if we create an India judicial stack and allow private innovation on it, using of technology could help us in reducing pendencies. And for this, we need to rethink on how judiciary will use technology. So I would end by playing a nice song for all of you. We gave a prompt saying, create a song of 30 seconds showing the expanding horizons of AI in law. And this is what we got. I don't know how to do that. How do we play it?
Though we were looking forward really for the song to be heard, right? But nevertheless, we have ample amount of time to fix that later on. Ladies and gentlemen, I am going to call upon my next speaker. For now, with the previous honorable speaker, we knew that the ideas are equivalent to currency and IP. And right commands are equivalent to the less salary paid in AI. With the right command, you reach the right precisions. And with the wrong ones, you can end up in a really wrong place. And who marks the rights and wrongs of AI? So for that, I am going to call upon my next speaker. Our next speaker has been deeply involved in shaping India's cyber law, digital governance, and data policy architecture. He has worked extensively on cybersecurity frameworks, intermediary regulations, and national data governance initiatives. With decades of policy-level experience, he brings a rare perspective on how data protection, cybersecurity, and ethical frameworks must evolve alongside technological innovation. Today, he will discuss the critical intersection of AI, legal ethics, and digital governance. Please welcome Mr. Rakesh Maheshwari, former Senior Director at the Ministry of Electronics and Information Technology.
So first of all, thanks a lot for having invited me here. I was an engineer when I passed out from the college. And after having worked in Ministry of Electronics and particularly in last 10 years in cyber law, I'm now neither an engineer and in any case, I was never a lawyer. So I'm at a completely, I'll say, at odds. But definitely having worked in the area of cyber law, IT administration, cyber security, and the data protection laws that were coming up during my tenure, I will like to maybe address their importance, their relevance, and their requirements as is applicable to the legal, I'll say, ecosystem. Thank you. When we are talking of the legal system today, we have e-courts, we have virtual hearings, we have digital filings, we have digital evidence, and therefore, and maybe many more things in digital. In any case, AI has already come up. I have also used AI in framing some of my slides today to make it simple. Not that I couldn't have made it, but definitely it helped me to make it simple. And I have used my critical thinking to be able to develop the right story. So, in view of, as I mentioned, the relevance of, in view of the activities that are being carried out in the legal system, certain requirements have become very, very relevant for all of us to know, and they are in relation to the privacy, the Data Protection Act that we have. They are in relation to the security. The IT Act does provide the framework for the cyber security, but there is a component of security in DPDP Act also. We have the AI India AI mission coming up with AI guidelines. So we have the right frameworks available, just be conveying, quickly discussing all of them in our context. So DPDP Act, for that reason, is the first comprehensive law in respect of privacy in the digital space, Digital Personal Data Protection Act, which has come up because of privacy being declared as a fundamental right, and hence a right-centric based Personal Data Protection Act, applicable to practically all organizations, and including lawyers, including legal firms, including judiciary, including any other stakeholder, whether in government or otherwise. So mostly consent-centric governance requires data breaches, if there are any, to be reported. And why I am talking all this is not that we did not have the concept of privacy and data protection in the IT Act and the SPDI rules, which are there in place since 2011, but the scope has expanded significantly, something which was only meant for security and reasonable security of SPDI, sensitive personal data and information. That too obligation was in respect of body corporates, is now applicable to all personal data in the digital or digitized form and to all sorts of organizations. Can we move? Not only it says, it clearly conveys the obligations of the data fiduciaries in respect of maybe taking consents, in respect of ensuring that the data remains accurate, in terms of controlling all those stakeholders with whom you are sharing data. And particularly in the legal community, while you may be very good, and you are very good, in fact, in maybe drafting, in taking the cases, in filing, in all digital activities, you may not be that good in the IT related activities. And hence, there is a dependence on the external, I'll say, ecosystem. And because everything has moved into digital space, it is quite likely that while you deal with personal data, in fact, you deal with very, very sensitive personal data, maybe medical, maybe financial, maybe other forms of medical data, personal data, maybe so many evidences relating to, once again, where components of personal data is already into it. Therefore, it is essential that as data fiduciary, you understand your obligations, and in case you are dealing with children data, there are additional obligations. In case you are dealing with disabled persons data, then once again there are additional obligations. In respect of cyber security, once again we have in the DPDP Act, it very categorically says that whatever personal data that you have collected or are processing or maybe are outsourcing and hence getting processed, in each of these cases, it's important that no security breach happens, no data breach happens. So today, if a data breach happens, there is no liability per se, except in case of SPDI. But as the law gets implemented, law becomes operational, which it is going to become operational by May 2027. The dates are very, very clear. So clear obligations have been casted in the law to ensure security of the personal data and to report any breach if it has happened, maybe intentionally, maybe unintentionally, maybe by the processors, by those companies which are working for you, but you continue to be liable for it. Of course, we have under the IT Act a clear cyber security framework available. We have 24/7, Indian Computer Emergency Response Team, which you must have heard of in last 3-4 years. It's very popular. Whenever, if it says government comes up with some security advice, some security directions, some security incidents, you will always hear the name of CERT-in. CERT-in, for that reason, has clearly directed that all organizations in the country, whether in government or outside, private, have to report a cyber security incident within 6 hours. So that's a legal mandate for all applicable, for all organizations, including, as I said, government organizations. But Certain being a technical organization is not a very good regulator, and therefore they have focused continuously on the technicalities of the security and helping organizations to maybe avoid such vulnerabilities, weaknesses in the future. As far as DPDP Act is concerned, it clearly puts the onus on you. Failure to report, failure to maintain security will attract penal provisions. Of course, it brings a lot of business opportunity, but it also creates, as I said, obligations on you. We can move to the next. We have already talked about few of the AI tools. In fact, as I said, this is where I also have used the AI tools to be able to come up with few of my answers. So some of the tools which are being used, and in any of these scenarios, the risk is bias. The risk is hallucination, and hence what is really required is the critical thinking. Definitely you must use the tools, as many as tools as possible, but please ensure that while using the tool, no private personal information is going outside the organization, that the data remains secure, and that the references which are being used continue to be correct, and hence critical thinking must go into any help that you are taking from the AI tools. Can we move to the next, please? And hence the ethical usage of AI becomes important. Maybe we can practically move to the last slide. So therefore, because the time is short, I'll just like to convey the conclusion that we have a well-defined data management and I'll say data protection law. We had a poor, I'll say, data protection culture. So upgrading our culture to meet the expectations and the requirements of the law, therefore, is essential. We have lots of usage of AI, and hence it is important that we use these tools wisely. We ensure that the data protection, the personal data does not move outside the organization, and the data and this personal data does remain secure. Stakeholders therefore must adopt secure, ethical digital practices. With this, I like to end my talk. Thanks a lot. Thank you very much.
Thank you very much, sir. The moment has arrived for which we will all be waiting since this evening. And me especially, and the team who has organized this event since past many days or weeks or so. It's now my privilege, ladies and gentlemen, to invite our chief guest, Honorable Justice Sanjay Karol, whose judicial career reflects a deep commitment to constitutional values, access to justice, and institutional strengthening. Justice Karol practiced for a long duration in the Delhi High Court, whereafter he was designated as a senior advocate in 1999. He was also appointed as the Advocate General of the state of Himachal Pradesh, whereafter he was appointed as a judge of the said High Court in 2007. Justice Karol was elevated as a judge of the Supreme Court of India, and as he has arrived already on the dais, I now request all of you to please welcome the Honorable Justice.
A very good evening to all of you on the dais of the dais. To begin with, I must thank Hon'ble Mr. Justice Sanjay Karol, Mr. Anil Sapra, for having given me this opportunity of being here. Star of the evening, Justice Pratibha Singh, and Shri Balkrishnan, Shri Rao, Shri Maheshwari. You have really educated me on several issues, I must acknowledge that. To the organizers, my compliments, and assured availability anytime, whenever you want me to be there. I come here nostalgic, because I was part of you at one point of time. I told Mr. Sapra that when he called me up, he said he wanted me to be here. I said, anytime, there's no difficulty. Artificial intelligence is a subject which is really emerging, a thought which has to be taken forward, leaps and bounds. It is bound to stay here. There's no doubt about it. It is no longer a speculative or futuristic technology. It is already being deployed across a wide range of sectors. In healthcare, AI tools are assisting in early cancer detection through imaging analysis. In finance, algorithmic systems are used for fraud detection and risk assessment. Governments, regulators, and courts across the world are therefore confronted with the challenge of understanding how to integrate this technology without compromising constitutional values, procedural fairness, and human dignity. In India, the Constitution provides the normative framework within which any technological adoption must occur. The court's jurisprudence on privacy, due process, and reasoned decisions makes it clear that technology cannot be allowed to undermine fundamental rights. Any use of artificial intelligence within the justice system must therefore be tested against the constitutional principles of fairness, transparency, and accountability. Across the world, jurisdictions are beginning to respond to these challenges through regulatory framework. Of course, it is there in India, as just Mr. Maheshwari mentioned. The European Union's Artificial Intelligence Act represents one of the most comprehensive attempts to regulate AI systems based on risk categories, with strict obligations for high-risk systems used in sectors such as law, enforcement, employment, and critical infrastructure. India may adopt or may not an identical regulatory model. Developments such as this demonstrate that the governance of artificial intelligence is rapidly becoming a central question of public law. Artificial intelligence offers benefits, significant at that, when deployed responsibly. It can process large volumes of data, identify patterns, and assist human decision makers in areas that would otherwise require substantial time and resources. In sectors such as disaster management, public health, financial regulation, AI systems have already proved efficiency and responsiveness. We just saw what SEBI has done. Scholars world over have observed that AI systems are often effective in tasks involving pattern recognition, prediction, and large-scale data analysis, while remaining limited in areas requiring moral judgment, contextual understanding, and human empathy. But I must emphasize here, the challenge for institutions, including courts, is therefore not whether to use AI, but how to use it in a manner that enhances rather than replaces human judgment. Within the judicial system, artificial intelligence may have both administrative and limited judicial applications. On the administrative side, AI systems can assist in case management, including translation, data recognition. Supreme Court, as has been mentioned earlier, has evolved application SOAS initiative, which uses AI-based tools to translate judicial documents into regional languages, enhancing accessibility. In other jurisdictions, courts are experimenting with AI tools under the controlled conditions. For example, in Qatar, they have introduced guidelines permitting limited AI assistance in judicial processes, subject, of course, to strict human oversight and accountability requirements. China's smart court system, implemented by the Supreme People's Court, uses AI to identify verification, online documents, accessing, remote mediation, and remote proceedings. In May 2023, an AI police unit was created in China, one of the provinces there, to apply AI in detecting suspicious behavior, preventing crimes, and combating fraud. I may refer to some instances of AI directly being used on judicial side. In the United States, the COMPAS, COMPAS, algorithm has been deployed to assess risks which judges may consider for bail, sentencing, or parole decisions, although it has raised concerns about bias. The star of the evening was telling me how biased they are. In China, smart courts such as International Court uses AI to analyze evidence in intellectual property, online commerce, generating preliminary judgments and recommendations that judges review before issuing final decisions. It is a different matter now that the law firms in India are using AI to predict what judgment a judge would deliver. These developments demonstrate that courts worldwide are exploring the cautious use of technology while attempting to preserve the integrity of the adjudicatory process. These examples make it clear that while AI may assist in administrative or research tasks, the responsibility for accuracy, reasoning, and decision-making must always remain with human judges and lawyers, a major stakeholder in our justice delivery system. The responsibility for the ethical and responsible use of artificial intelligence does not lie with any single institution. It is shared amongst judges, lawyers, policymakers, technologists, academic institutions, and civil society. Courts, in my considered view, must ensure that any use of AI remains consistent with the constitutional guarantees under Article 14 and 21, particularly the requirements of fairness, non-arbitrariness, and reasoned decision-making. Developers of AI must recognize that technologies deployed in the justice system are not neutral tools. They embody design choices, assumptions, and data patterns that may shape outcomes in subtle but significant ways. Two professors in Harvard, Aurel Bar-Gill and Cass Sunstein, have written a book on algorithm harm, which shows how it can be used to design or exploit behavioral biases, nudging individuals toward decisions that may not serve their long-term interests. Such dynamics can disproportionately affect already vulnerable groups, including women, persons with disability, lower income communities, and the historically marginalized groups, thereby deepening the existing structural disadvantages. When we talk of AI, we must also keep in mind those who are not living in the cities. We have to think of those who are there in the villages and who have no access to justice, who have no voice, no say, or no face for that matter. If at all AI has to be used, it has to be used for their upliftment more so. In a diverse society, such as India, poorly designed AI tools of those learning from past practices may inadvertently deepen the very inequalities the Constitution seeks to remedy. Policymakers must therefore ensure that technological adoption remains aligned with constitutional morality and social justice. There are pitfalls for every evolution. Recent global experience offers important cautionary lessons. In the United States, a lawyer was sanctioned after submitting fictitious AI-generated case citations. Our own court, the Supreme Court, and the star who's sitting here has already cautioned the legal fraternity of being cautious or not giving citing judgments which are AI generated. Am I right, ma'am, on that? So has the Bombay High Court done that. Concerns about confidentiality have also arisen. Illustratively, Samsung reportedly restricted the use of generative AI tools after employees uploaded sensitive proprietary information into such systems. In US, cybersecurity authorities have similarly warned of risks in government use of generative AI tools after Madhu Gotamakala, Acting Director of Cybersecurity and Infrastructure Security Agency, had uploaded some documents to one which AI chatbot. In my considered view, I see a lot of students here, a lot of law interns, I was told by Justice Pratibha Singh. Students present here will encounter artificial intelligence in their academic and professional law lives. During internships, you may use AI tools to proper research, notes, organize materials, or summarize documents. In universities, such tools may assist in assignments or preliminary research. The use of artificial intelligence cannot be painted as entirely good or entirely bad. It lies somewhere in between. The challenge is to find the right balance. Efforts to understand the law cannot be replaced by shortcuts through AI tools. If learning is outsourced to a machine, the learner ultimately bears the loss. Much like in judicial work, AI in legal education must remain strictly supplementary, and even then used with heightened vigilance. The responsibility for understanding analysis and reasoning must always remain with the student. I may also say this, that, and I'm building really what my former speakers have said, that I would like to turn to a different but equally pressing dimension of artificial intelligence, namely the role it plays in addressing environmental distresses and ecological crises. Everyone knows I'm a great environmentalist. Artificial intelligence has to be used, in my considered view, more so in view of the climate change. Across the world, artificial intelligence is increasingly being used to monitor deforestation, predict floods, detect illegal mining, and assess environmental compliances. Academic research shows that AI systems are particularly effective in areas where large volumes of environmental data must be analyzed in real time, such as satellite imagery, climate and modeling, or population tracking. For a country like India, these possibilities are especially relevant. And I must say, most recently, the monsoon-related disasters in Himachal Pradesh involving landslides, flash floods, and infrastructure collapse resulted in significant loss of life and property. Such events underline the importance of early warning systems, real-time monitoring, and coordinated disaster responses, areas where AI-assisted models can play a significant role. what is the way forward? Honorable Justice Karol has already mentioned about it. I may only add, we have to adopt a cautious, principled, and constitutionally grounded adoption of artificial intelligence. Technology must remain to assist as a tool to human decision making and not a substitute for it. At the end, I may add that the day that we need a proper expert-informed system duly laid out and empowered by Parliament is not far. AI is making its way into every aspect of life, and so to ensure that there is a mechanism dealing with vexing issues such as data protection, accountability, liability, and AI regulation in general, such a law is required. Maybe also with the Council to stay on top of the ever-increasing speed of improvements and developments. After all, our citizens cannot be remediless, reduced to just numbers and database. From automation to augmentation, the new term which I have learned today, I look forward for the day when the last man on the street in the rural area uses technology, having access to justice in his own voice, expressing what he wants and getting what he is just fair for him. Thank you very much, please.
Thank you so much, Honorable Mr. Justice Sanjay Karol. As a token of our sincere appreciation and in grateful remembrance of the valuable presence and guidance on this occasion, we would like to present a memento to the honorable guests present on the dais. May I request Mr. Sachin Puri, the Senior Advocate and the Vice President of the Delhi High Court Bar Association, to present a memento to Honorable Mr. Justice Sanjay Karol, our Chief Guest. May I now request Mr. Jugal Wadhwa to please present a memento to Honorable Mr. Justice Sanjay Kishan Kaul, our patron. May I now request the co-founder of Innovate Legal, Mr. Bharat Malhotra, to present a memento to Honorable Ms. Justice Pratibha M. Singh. May I request Mr. Rajesh Mishra to please present a memento to Dr. Janendra Balakrishnan. And may I request Mr. Davendra Grover to please present a memento to Mr. Pramod Rao. And Mr. Lakshya Kaushik to please present a memento to Mr. Rakesh Maheshwari.
Thank you very much. Also, thank you to Shri Alok Sapraji for this gratitude session and for the insightful, knowledgeable session that we have received from all our guests. Thank you very, very much. You see all these gentle faces of our distinguished guests sitting on the dais. You will never know the violence it took to be this gentle. And if you understand, give a huge round of applause to our dear guests who are present here. So wonderful to have you all here at this wonderful summit, and we really, really look forward ahead also. Thank you very much, dear guests. We will move on to the panel sessions, but we are really grateful and happy that you have graced this occasion. Thank you, thank you, thank you very much. Also, ladies and gentlemen, let's take a moment, stand up at our places and thank our dear Honorable Chief Guest of this evening, Honorable Mr. Justice Sanjay Karol. Thank you very much. insightful and intellectual panelists who have came here from the lengths and breadths of this country only for you all. Please take your seats, ladies and gentlemen, and let me guide you through what is coming ahead for all of you. We are moving ahead to the panel discussion over law, AI, and governance opportunities, risk and road ahead. This session will be exclusively moderated by Mr. Akshay Sapra, our co-founder of Innovate Legal Foundation. Before I proceed, I would really like to request all of you to be seated, because for your surprise, the panelists who have come here will be a lot of your interest. Let me just name all of them, and then I will be inviting them up on the stage gradually, one by one. For now, let me tell you the speakers who have come here exclusively for the summit. Dr. Shardul S. Shroff, Executive Chairman of SAM & Co. We have Ms. Meenal Das, Senior Corporate Counsel, Microsoft. Mr. Vikas Mahindra, Terrace AI and Joint Secretary of Arbitration Bar of India. Dr. Karnika A. Seth, Cyber Law Expert, Ministry of Defense and Ministry of Electronics and IT. We will be having a huge discussion over all the questions and the bits and pieces of AI, which has been scattered since day one. The AI has been included in our lives and introduced to us. All the speakers are here, all the panelists are here, you are here. I request all of you to fill up the empty seats so that we are more closer to the knowledge session and more closer to our panelists. If there are many students who are sitting here, there are many seats ahead. Please, I request all of you to fill up the seats ahead. We have many empty seats out here right now. Please come up. Thank you very much and settle down. Ladies and gentlemen, now we are beginning a new discussion, opening a new portal. No, we are not transporting you anywhere else. We are right here in the session of AI. लोग कहते हैं AI जब से हमारी जिंदगी में आया है तब से हमारा काम कम हुआ है. We are not at the same poles. Law and normal life lives poles apart. As the introduction of AI into our lives, the responsibility of the practitioners have increased tenfolds. Ladies and gentlemen, this session will be moderated by, yes, of course, our very own Mr. Akshay Sapra. Give him a huge round of applause first and foremost for introducing us to this wonderful summit, introducing and collaborating law and AI together. Moderating this plenary session, Mr. Akshay Sapra, a legal professional and founding member at the Innovate Legal Foundation, with experience in corporate legal strategy, project financing, and dispute resolution, he actively drives cross-sector dialogue on law, technology, and governance. With a huge welcome, this responsibility now rests on the shoulder of Mr. Akshay, that they get what they have come for. And it is my time, the last duty of mine, to introduce you all to the wonderful panelists sitting here. Ladies and gentlemen, one by one, with huge round of applause, welcome Ms. Meenal Nasa. Senior Corporate Counsel at Microsoft, works at the forefront of technology regulation, digital compliance, and responsible AI governance. She brings the perspective of a global technology leader on how legal systems can enable innovation while ensuring trust and accountability. We are welcome, grateful, and honored to have you here. Thank you very much for being here, ma'am. Also, ladies and gentlemen, let me take you forward and make you meet one more passenger of this journey, Mr. Vikas Mahindra. Associated with Terrace AI and the JS Arbitration Bar of India, focuses on integrating AI and analytics to arbitration and dispute resolution. His work highlights how technology is transforming the way complex disputes are managed. Please welcome him also with a huge round of applause. Thank you very much, sir. We have Dr. Karnika Seth, ladies and gentlemen, a noted cyber law expert, advocate and advisor to national institutions including the Ministry of Defense, is a legal voice on cyber law, digital rights and technology governance. Please join me and welcome Dr. Karnika Seth. We also have Mr. Sarvesh Kumar, founder and CEO of Evenstat.ai. He is building AI-driven platforms that enhance how large-scale conferences and knowledge ecosystem operate through data-driven insights and smarter collaboration tools. Please welcome Mr. Sarvesh Kumar with a huge round of applause. Taking you to the last stop, Dr. Deepak Singla. Ladies and gentlemen, the Medical Director of Maharaja Agrasen Group of Hospitals with over 4 decades of healthcare leadership experience, a Six Sigma Black Belt and co-author of my Medical Legal Guide. He actively works at the intersection of healthcare quality, medical legal policy and the ethical adoption of AI in healthcare. Let us join hands, welcome him and welcome all our panelists. Mr. Akshay, this session goes to you.
Thank you everyone for joining us today as we discuss this crucial topic. I'm going to start with the conversation with the recent mention of judicial reforms which happened at Davos at the World Economic Forum by Geeta Gopinathan, the former chief economist at IMF, on how they remain one of the biggest impediments of India's growth, and little has been done to change the same. AI has the potential to change that, but it has to be done the Indian way, right? And by that, I don't mean being one of the last major economies to adopt AI laws like we did for data laws, but be more adaptive to the Indian ecosystem. So with that, I asked Dr. Seth, you have long advocated for AI regulation and shared proposals with the government. Concretely, if you can explain a realistic roadmap for integrating AI into the judicial ecosystem, just if you can prioritize 2 points, 3 non-negotiables for the Indian judiciary, and who should have an oversight during this pilot?
Sure, very pertinent question indeed. So I come from the tech world as well as the legal world, so I'm going to bridge the two. And as a practicing cyber law in this field, with the growth of AI and India AI mission and other activities around the place, the most pertinent question, as Honorable Justice Sanjay Karol also mentioned, was how do we integrate AI in the judiciary, in our judicial systems? And if you would look at the thought when he left his speech in the end, he said every particular person, the last person in the village should have access to justice. So I really, I absolutely advocate the same, and I endorse what his vision is, because for India, I was also fortunate to be a part of the India, the e-courts filing system, which was, set up initially with phase 1, phase 2, and then I also had the opportunity to write the manual for e-filing for high courts and district courts. So having seen the growth and having seen the onset, I strongly feel that AI has a huge potential for our judiciary. And our key vision, as I would say in my considered view, would be that we should have speedier justice. And in order to remove the backlog, we should be able to enable, with the help of AI, access to justice delivery across all rural India as well as the urban India. That's one. And how do we do that is your question. And second is also the fact that not only this, but how quickly can we bridge the language gap? Because we have so many languages in India. So maybe a chatbot which can ease and bring easy access to any common person to even use his voice to just like we have Chat GPT, we can he can say that I want to the status of my case, or I want to file a particular complaint. Which court do I file it in? What is the court fee? Basic things, basic legal aid services could also be provided to that particular litigant. That will be really a big leapfrog. That is what we are envisioning. So in my view, AI is an enabler, not a disabler. And if you agree with me, ethics forms a part of the technological governance today. And when I say so, I clearly know that this is, what I'm talking about is the use of responsible AI. And what is responsible AI? As rightly explained by the judges, human oversight is going to be irreplaceable. I mean, judges can't be just automated AI systems. We have to have human oversight, but at the same time, how can we use AI unless we are sure that this is going to be fair? This is going to be unbiased. And there will be no black box. We will know what exactly is the algorithm which is being used. It is going to be auditable. It is going to be transparent. And at the same time, have enough security and privacy in place. So unless we have those, criteria met, we will be reluctant to put in AI in the judiciary. So our vision, 2 use cases you mentioned, I have given you. One is to bring more access to justice, even to rural India, and 2 is to use even voice by voice to text, like chatbots. And completely non-negotiable is one is the human oversight element. Number 2, it should be rights protective. Rights of citizens, constitutional rights have to be protected. And number 3, it has to be auditable. When I say auditable, they have to be standards, like ISO 42001 is one of the standards of AI, which ensures that this AI is not a black box and it is clearly and transparent, and whatever has gone into it for training is known. So that is absolutely what my take is on this aspect, right?
Thank you. So, as Justice Pratibha Singh mentioned the judicial stack, which she would like to see our courts develop. On the idea of the Indian way, which I just mentioned, for judicial adoption of AI, what practical steps, Meenal, you think the government and the courts should take to adapt to the international best practices to the Indian institutions? And what do you, given the resource constraints that India has?
So, first of all, thank you, Akshay, for inviting me. It's an honor to be here. And it's an interesting question. So, when I think of the India way, I think we need to ask a very simple question. What kind of problem are we trying to solve in India? Because in contrast to the Western world, India operates at a completely different scale. We have massive pendency of cases. There are language barriers. There is the courts. The courts are not equally developed. The IT infrastructure, all the courts are not digitized. So there is uneven access to justice. So while the Western world is more aggressive with experimentation of AI, they are driven by efficiency. I think for us, for the Indian judiciary, the main question is how do we, and as Justice Karol, Justice Pratibha also mentioned, the main question for us is how do we ensure access to justice. So adoption of AI in India would be grounded in access to justice, and we have to start with those pain points. As I mentioned, the language barrier. So translation is one of a key feature of AI that we really need to adopt. And our judiciary is already doing these pilot projects. There are IT committees which are there, which are already, courts are adopting these translation tools to make justice more accessible. We're using AI in docket management, case management. So it is a cautious approach, and as everyone today has said, human oversight is critical. AI has to be assistive. It cannot control us, and AI should not be used for interpretation or flaw or giving judgments. It has to be assistive. It has to help with the administrative efficiency. And the AI that the judiciary in India needs to adopt does not need to be only powerful, but it should have the right governance controls as well.
Excellent. So, one very pertinent factor which I think Mr. Maheshwari mentioned in the last sessions were the tools which are now being used in AI research. So, with general purpose AI tools entering legal research, who bears the primary responsibility, meaning for the quality and safety of the work done? Law through AI. Is it the platform provider? Is it the law firm? Or the in-house counsels you feel? Or the regulators? On what is the minimum safeguards you feel that should be placed?
So as we've been talking about human oversight over everything, I think the professional liability of what is being filed on courts or what are you delivering remains with the lawyer. But it is a primary responsibility. There is also a shared responsibility of the IT providers, the AI providers. Their responsibility lies with product design. They need to have privacy by design. They need to provide tools which are secure, which the data, the prompts that you're putting in the AI model should not be used for, training their systems. There needs to be ongoing testing regarding bias and hallucinations. So from an IT provider perspective, they need to ensure that the systems are compliant, while the accountability for legal interpretation, for legal advice and legal research rests with the lawyer.
Excellent. So Vikas, your company has developed dispute resolution technology across jurisdiction. From a purely governance perspective, what regulatory or institutional differences most strongly influence adoption? Be it procedural rules, confidential norms, enforceability. Any concrete regulatory or procedural changes which Indian policymakers should consider to balance innovation with procedural fairness, you think?
Example of where regulatory support, regulatory oversight can go hand in hand with technology adoption. So I'm co-founder of a company called God, which is an OER platform, which is one of the OER platforms that Sudhomota mentioned, which talks about dispute resolution and ecosystem of it. There, what are the institutional oversights that are there? From timeliness of proceedings, from accessibility standards, from quality controls for arbitrators, from reporting mechanisms on, about 50 to 70 parameters that the regulator is looking at. All of that is how you ensure that technology is not allowed to run like an engine. In the international context, I think we talk about translation being one use of it. We had the privilege of providing that in real time. The DIC code and the Abu Dhabi Open Markets code, where our technology is deployed for transcription. One of the use cases is exactly that, where a lot of clients who come to the court don't speak English. And especially in these special economic zones, English is the language of proceeding. So what we've been able to do there is translate in real time the proceedings from English to Arabic without a human interpreter in the room, achieving the level of accuracy which surpasses simultaneous human interpretation just by certain pieces of technology. So that's again another space where the support of the core mechanisms to make accessibility possible makes it useful. A challenge with the union, and we talk about regulatory constraints, one extreme example I talk about is we actually do a lot of arbitration during to involve Russian parties. And for a lot of the matters, they simply were unable to use the tools that are internationally available. I mean, if people have traveled to Russia in the last 2-3 years, MasterCard doesn't work, Visa doesn't work, Switch doesn't work. So when you have core systems that an entire country's banking system depends on, and if those are, at the whim of a gentleman of the stature who starts to be the president of a large country which are not made, you can see the unpredictability that geopolitics brings. So I think a huge regulatory challenge when you're looking at the adoption of AI, particularly in the sort of legal and judicial context, is that self-reliance. Of course, that has to be balanced with trying to use the best model there is, but always shielding yourself against that risk, because those risks in today's world are very real. So some of those things are regulatory support to make accessibility a real issue, regulatory oversight to ensure that AI technology is not running around without control, and third, building enough safeguards to ensure that any sort of adoption of technology does not compromise national sovereignty.
Excellent. So translation and accessibility do remain a crucial problem when it comes to that. And AI, I believe, can solve that. Very well said. So Sarvesh, coming to the only engineer and a builder on the panel. So you have built AI products used by large organizations. What legal or design features do you proactively embed to ensure compliance, transparency, and auditability? In other words, how should law function both as a public guardian and as an enabler of product innovations, which you do?
See, third engineer in the room, by the way. If I give any examples which is non-contextual, again, the same disclaimer as Dr. Balakrishnan gave earlier. Now, this is a two-part question, right? And I would rather take the second part first, where what is the role of law? Because that's more critical than what features to use in a product, to be honest. Right? So now when we talk about role of law, right, with DPDP coming in, with GDPR coming in a lot of our sectors, there needs to be a balance. The law is the balance between growth and inclusion, right? So whenever we talk about AI, and especially, I mean, I see a lot of younger audience here, right? And they have been very keen on using technology, right? And since the time we've come here, we've spoken 2-3 times that we have a lot of lawyers, we all understand law, but we do not understand engineering, right? I think law, like how everything has evolved over a period of time, right? So earlier, if your MBA used to be finance and marketing, or earlier it used to be just general MBA. In law, it would be criminal law, corporate law, or something of these sorts, right? Now, I think over a period of time, it will automatically become a necessity where, while I understand how a law works, right, I also need to understand basics of data flow. A combination of the two will be the only person who can, if validate, and then provide a way around. Right? Now, you asked me for an example of the first question. Let me give you an example. Pratibha ma'am was there. I'm so sorry. Honorable Justice Pratibha ma'am. Sorry. So when she was here, right, remember there was a song she wanted to show, right? We have, and if we see the registration, we have close to 200-250 people who have been here, right? So in this process, what has happened, right? We have email addresses, phone numbers when they were registering of all these people. Now imagine if I tell you there's an AI tool where you just put the data in and these songs will be published and sent to all these guys. Sounds like a good plan, but this is where DPDP and law comes into picture, right? If I haven't asked or taken consent from the people to share certain information, that's where the consent comes into picture. And very recently, I spoke to one of the lawyers.
You developed a product, and there were some challenges with the.
I wanted to give that example. By the way, there was a couple of products that, and see, I build AI products, so there were a couple of products which got shelved because of legal understandings, right? And if I get into the details of it, it's slightly more technical, and there's too many lawyers. Sorry. And if someone comes back to me saying, you mentioned that last time, right. So
but primarily
I'm just holding back on that.
More proactive towards innovation.
Yeah. So now coming to this, right? So now you spoke about the features that are needed. Now, if I need to build the AI bot, what does is the moment someone says that this needs to be published to 8-10 people. Now, how we build the product is in a way where when we are taking the registration, we need to think through what are the different use cases that are needed for it, right? And hence take consent. Once we have taken consent, now that we are also taking the email address, you also have to have a DLP, like a data leakage protection. Now, an engineer will know that these things happen. Right? And how it moves, how the data moves, and things of those sorts. A lawyer says that this needs to happen. Right? If a certain, when we talk about teaching AI, right? We all speak about getting better at AI, learning more about AI. There are 3 steps before AI. The 3 steps are data engineering, deep learning, and then comes your AI, right? Your data engineering, rule-based algorithms and things of those sorts. Now, when you talk about deep learning talks about depth of data. And whenever there is depth of data, there is going to be questions around PII. And if my lawyer does not, 1, understand, and 2, show the engineer the way around, that, hey, you can't do X, Y, Z, but you can use your data flow from PQR. That is the only way this moves. And that's my opinion.
At this point, very interesting when he was just sharing this view. Whenever we do policy and whenever we do national projects, for instance, we always say that involve us in the first place. Yeah. Because otherwise you will be actually going from Z to A again. So the ABC, it cannot evolve. The AI integration or AI evolution, in fact, or incorporation cannot happen unless it is legally compliant at the outset. So I completely resonate with what she's saying.
So precisely that, right? So tomorrow I see a certain section of data law, So that's pretty much my opinion.
If Riji is in the audience, and when we've done policies for the government at that time, we would go back and see how things will be and how futuristic we need to be. So he can relate to.
I'll get in Dr. Singla also in this conversation. He's so at the intersection of Dr. Singla, at the intersection of healthcare and AI. What are the immediate medico-legal and ethical safeguards that a hospital must adopt? Hospital being an institution itself, where validation, liability allocation, informed consent or audit trials can be taken into account? And how should regulators and hospitals share responsibility for clinical validation for post-development monitoring?
Thank you, Akshay, for having me here. I'm really expressing my heartfelt gratitude to be among such luminaries. I am a doctor, and basically we all understand that India is a vast continent, and as such we are short of manpower, nurses, doctors, and AI definitely is there to help us, but problem is validation of all the AI algorithms. See, when AI is made to read legal documents, let's say even in US or anywhere, at least it will be reading same paper everywhere. But we are dealing with human beings, and all human bodies behave differently. So an AI tool which was perfect in US might not be the same in India. So we have to undergo rigorous validation for each and everything. Otherwise, patient is going to ask the doctor that I did ask you to use all these things. Then health literacy as such in our country is very low. Leave aside AI literacy in health. That adds further problem to the doctors. And as such, the whole medical profession is always worried about liability. I am sitting in front of all legal experts. So for the last 30, 40 years, since the time I started doing as a doctor the practice, now whole paradigm is shifted. First and foremost thing is we are always worried about the consequences of the legal things. Like what if we don't order a CT scan? What will happen? Whether patient will take us to the court? And let's say I as a physician used some AI tool which was supposed to be all right. But one in rare cases, it did not yield with the so-called perfect results. Now, who bears this liability? Doctor or AI developer or the hospital? Normally, AI developers get away by writing all these things to be, they are the experts actually. Doctors are not that much legal experts. We spent all our life, studying our medicine only. So, as I was sitting here, I thought now we will have to write another book. The book which I wrote with Malhotra ji and all might become outdated in the next 2-3 years because so much of data privacy and conversations, how much to talk to the people, and our poor bolum will again become different. When, half of the country is using AI-assisted medical technology, what will happen to the bolum against whom we are all tested? People will expect that most of the people should be using because that may become the reasonable person or the standard of care may also change. So I will anticipate that sooner or later regulatories like National Medical Council, and I will seek clarity from all the legal fraternity sitting here to help us actually tell AI is definitely helpful. We have studies where, it is great in making diagnosis, it is great in endoscopies, radiology, imaging, everywhere it is helpful. Provided we have a clear-cut mandate from the NMC so that all the doctors can use it freely, it will become a game changer actually. Because we have a huge lot of people, a lot of work, and in automation it has definitely helped in the hospital day-to-day working, but decision making, we will be there to adopt it once clear regulations are there.
Absolutely. I think that's largely been the case from all the panelists, all the speakers here today, that there has to be a human in the loop. And there would be eventually products, AI products, which will be coming out, which will help you get across legal boundaries in your specific domains, both be it in engineering or healthcare. So this last question, which I'll pose to the entire panel. to everyone, including the engineer and the doctor on the panel, is do you think, does the rise of AI in creating a two-tier justice system, one where human lawyer is in the loop, and another low-cost version in which low-cost AI tier version for the masses, is there any policy intervention that would prevent the outcome and ensure equitable justice to all? What are your thoughts on that? Yes.
So, having been involved with the e-filing code system, we envisage that for future we would be able to use maybe chatbots for voice to text and enable the rural India also to get speedier access to justice. Number one, that's. Number two is that backlog of cases. We have more than 4.5 crore cases in India which are in backlog. If we are able to provide them speedier justice with that, that will be a game changer again in our in the judicial system. How we will do that? Obviously, the rights-based approach. The rights of citizens have to be respected. There should be auditability. The systems have to be audited, like AI 42001 as a certification I mentioned. And one needs to be very mindful of human oversight, as Justice Pratibha Singh was putting a stack. I put it like this in 3 or 4 steps. Number one, we see where we stand today, and we see the the national judicial grid that operates. We see the SUVAS and SUVAS that is operable at this point, and then we build on it with the regulatory layer. When we say regulatory layer, you will agree with me, cyberspace is converging. Globally, we are converging. And if that is the case, our laws have to converge. And that is why the talk of ethical, responsible AI around the globe. Are there any standards for judiciary? We've seen success stories in Canada. We've seen success stories in Brazil. Victor is used there. We've seen it in the UK. US, yes, US goes more towards even looking at analytics and predictive judgments, which we clearly stand up. Our boundary is very clear. We're going to have a human oversight. But then there are EU, for example, which has its own regulatory EU AI act, which is binding. But then there are soft laws. There is UNDP, AI for Justice. There's a new standard which has been proposed. There is also a UNESCO AI, again, in justice delivery. They have put up standards. However, we may choose to take clues from there. We may choose to build our own AI ethical charter. And there's nothing more appropriate than here bringing this proposal that we could maybe draft a charter of AI for our Indian judiciary. Why not do that? That is just one of my suggestions, because I also voluntarily at the G20 time drafted a proposed AI law for India for government to consider. And with the discussions when we had with the Hon'ble Minister, we were told that at that point, and even now, India has got a progressive approach and wants to only curtail or curb those systems which are high risk. And I do understand where that comes from, and that's fair. However, when it comes to deepfakes and problems like synthetic threats, digital arrests in the country, that is the reason why we have had yesterday a new intermediary guidelines amendment. That is the reason, because when I said that this will be required, maybe not a separate law at that point, when the G20 was taking place, but now the government also realizes, and having advised, I am an expert with the Ministry of IT as well as Defense. We realize the repercussions.
Right here on the dais next time the session is there.
Yes.
Any of your thoughts on this?
Sure, Akshay. I think the question around two-tier justice system being created, I think it's a very valid question and an important one to raise, especially at a time when a transformative technology like AI is entering the justice system. The risk is real, but it is not inevitable, I think. And the risk does not arise from AI itself, but how AI is designed, developed, and governed. Yeah. So if we use AI as a substitute for legal advice, legal judgment, or for pronouncing judgments, then of course there is a risk of a two-tier justice system where there is a section of society who can afford human lawyers plus the technology, and they get premium justice. And there is another section of the society who's struggling at the entry level. There are cost barriers, they don't understand the legal system, and there are language barriers. But if we use AI as a supplement to mitigate these barriers, the translation capabilities of AI, using AI to their voice to text and text to voice capabilities to explain the legal system for those who cannot read or who cannot understand in their language. I think then the gap, because the inequality in India already exists. There are some people who can afford human lawyers and others who don't. So if we use it to supplement the legal system, then of course I think we can reduce this equality. So it's actually the governance and how AI is governed which will decide.
Great. So we're being pressed for time, actually. So one final thoughts. Name one single legal regulatory change that you would prioritize in 2026 and make AI adoption in judicial systems safer and more effective. Starting from Vikas, 30 seconds.
Thank you. We're actually building something in the judiciary, and I slightly differ on the panel when they say that judicial decision making, whether they should not use AI. I think they absolutely should, given the high dependency levels, but with the safeguard. So the one thing that we've been working on, in fact, it's a running pilot with multiple high courts we have currently, is designing use of AI tailored for judges, which lets them make decisions faster, which bubbles up crystallized information faster, but is prevented from making decisions on behalf of the judge. So it is that balance that the courts are today already doing the pilot, which I think is going to be the most significant governance decision we take this year.
Excellent. Thank you. Dr. Singh?
Well, my take on this will be that when whatever number of high courts, I mean, there would be different high courts would have a different view on whether they'll allow an AI, to assist their courts. However, we need a charter, we need guidelines for it. It could be in a soft code form, and Kerala is one of the first courts which have just come about with an AI charter. And that is a good practice, I feel. If we can homogenize it, that will be the best way, because I know there could be divergences in the way they function, the different courts. However, if one soft code can give them a clear way of how one needs to incorporate AI in their registry work or in their assistive, justice delivery systems, I think that will go a long way.
Excellent. Thank you. 30 seconds.
Less than 30 seconds. I will probably, because I wouldn't know regulatory, my point would be probably to mix with the previous question of how, I think from our side, we are looking to get process automation first and fast. From predictive analytics and judgments being dependent on AI and data, I think we're far from there. It's quite literally, like imagine if you have a driver from US, right? Left-hand drive, automation, you send them to an Indian road, it will not work. So the first things first is to get the engine's ecosystem infrastructure ready to be able to get to that place. Which decision requires human intervention, which doesn't, will depend on training data, and all of those things is separate. But I think start would be something that I would be
ecosystem ready before augmentation. Yeah. Meeral, your thoughts. 30 seconds.
Yeah.
One change which you would like in 2026?
I'll keep it short and simple. I think a governance framework for judiciary, setting out the minimum requirements for transparency, auditability, and human oversight. There needs to be clear guardrails and not very heavy legislation. I think clarity builds trust, and trust is, I think, the foundation of AI adoption.
Great. Thank you so much for that. And
Can I just sum up in one line?
Yes.
AI can be both a boon or a bane, or either or. So you choose what you would want it to be. It's in your hands, right?
Correct. So with that, ladies and gentlemen, we come to the end of this panel discussion. Thank you everyone for being here. Thank you all the panelists for being here.
Thank you all so much. And may I now request Mr. Aditya Kapoor to present a memento to Ms. Meenal Nasa. Mr. Surjit Malhotra, may kindly present a memento to Dr. Karnika Seth. Mr. Rajendra Tripathi, please present a memento to Mr. Vikas Mahendra. Mr. Prashant Raj, kindly present a memento to Dr. Deepak Singla. And Mr. Kushal Malhotra, kindly present a memento to Mr. Sarvesh Kumar. She's there. And lastly, but not the least, Mr. Amit Grover may kindly present a memento to Ms. Megha Thakur. Thank you all so much. Thank you for being here. And may I request everybody to have a cup of tea with us, of course with snacks. And we also thank you for being held up for such a long time. And we'll definitely compensate you for the same in the evening snacks. Thank you so much, everyone. And there's a vote of thanks, 1 minute more. And I'll just request Ms. Bhumika Indolika, the co-founder, to just give a vote of thanks. 2 minutes more.
I'm so sorry, all of you. I'll take just 1 minute, not more than that. I'll not come in between your high tea and you. So, good evening, all of you. On behalf of Innovate Legal Foundation and the entire organizing committee of the Indian Law and AI Congress 2026, it is my honor to extend my heartfelt gratitude to each one of you. And thank you to the chief guest and the panelist and the speaker for joining us today. I'll just thank the Delhi High Court and S Block for providing us a dignified venue. And also the team, Mr. Anil Sapra, Mr. Rakesh Malhotra, Amit Chaudhary, Nitesh Mehra, Shrey Shehrawat, Devendra Grover, Jugal Wadhwa, Kushal Malhotra, R.K. Tripathi, Bharat Malhotra, Aditya Kapoor, Surjit Malhotra, Prashant Raj, Siddharth Handa, Lakshay Kaushik, Sanjeev Sharma, Sandeep Pandi, and special thanks to Meghna Thakur, our Master of Ceremonies, for anchoring today's proceedings with grace and professionalism. Our heartfelt thanks to all our partners, supporters, and volunteers, and behind-the-scenes team. As we conclude ILSE 2026, I would like to briefly share the vision of Innovate Legal. Our mission is to build India's premier legal tech and legal innovation platform, and that fosters dialogue, enables collaboration, supports responsible technology adoption, and strengthens access to justice through human-centric innovation. We envision Innovate Legal as a trusted bridge between law, policy, technology, and society. We invite all of you to become a part of this growing ecosystem by registering as members of Innovate Legal and to continue engaging with us through future Congress, research initiatives, policy dialogues, and capturing building programs. As we close today, let us carry forward the momentum of these conversations, continuing to collaborate, innovate, and build frameworks that strengthens the justice system. Thank you so much for all of you for joining us today.